Hello everyone and welcome to this Your Overseas Home webinar on why property owners in Spain may be owed billions and how you can make your claim. My name is Julian Benson. I'm a writer here at Your Overseas Home, and today I'm joined by Cristina Gaspar and Marianne Helgeson from JLCA Lawyers. They're specialists in Spanish property law. While we normally talk with people who are preparing their move overseas, today Cristina, Marianne and I will be talking about a problem that affects people who have already bought in Spain. From 2000 to 2016, many buyers in Spain were missold mortgages, which meant homeowners were paying more each month than they expected. The Spanish government has recognized that problem and it set aside billions of euros to pay compensation. And today we're going to be discussing whether you are owed some of that money. We'll be diving into the Q&A shortly, and please do use the box on the right side of the screen to ask Cristina and Marianne a question. But as a last housekeeping matter, if you need a reminder of anything that gets discussed today or want to share this with family and friends, a recording of this webinar will also be available on the Your Overseas Home website. We'd highly recommend sharing that recording with anyone you know who may have been impacted by the issues we discussed today. As you'll hear, it's something which may specifically impact you, or it might be that it's something which your neighbours may have been impacted by, your friends may have been impacted by. Really, anyone who has bought a home in Spain between 2000 and 2016 should probably investigate whether they've been affected by what we're going to be talking about today. Anyway, with that out of the way, let's get started. So let's kick things off a little bit. And if you could tell us a little bit about what the original problem was. What is it the banks did between 2000 and 2016, which is now being compensated?
So, Marianne, I don't know if you want to introduce a bit the situation. If not, I will do.
Yeah, well, basically, between 2000 and 2016, the banks, what they did is they applied some clauses which at the time were seen as legal and since have been deemed as abusive clauses. These were clauses that we call in English floor clauses, which means that if the interest rate went down, you would have in your mortgage deed, you would have a paragraph that would say that even if it went down, your mortgage could never go below, say, 5%. So you would never ever see the amount going down of your repayments, basically. Now, at the same time, there was also another index rate for IRPH, which was less favorable than the Euribor that was applied. And also, the client had to pay basically the notary fee, the land registry, and all the expenses such as the valuation fee, etc. All these clauses have been deemed as abusive since, and we can now make a claim for these.
Fantastic. Okay, so I suppose we should probably get into a little bit about eligibility, who this is going to be applying to, how wide the scope is of both the problem, but also the compensation. So if you're able to tell us who exactly is eligible to claim compensation, and does it matter if they no longer own the property or if they've repaid the mortgage already?
So basically, everyone is eligible if they had a mortgage, Spanish mortgage, at those years. So basically, everyone that bought a property between the 2000 and 2016, if they made a mortgage with a Spanish bank, obviously we understand that obviously they will be attached to the this kind of clauses, or maybe the Euribor. So normally all the people that had the mortgage, even if they sold the property, if they don't have the mortgage anymore, they will be eligible to claim all these kind of amounts.
All right, fair enough. And so is there any difference at all in eligibility whether someone was a resident of Spain or a non-resident who took out a Spanish mortgage?
No, in this case, it doesn't matter. So if they have the Spanish mortgages, it doesn't matter if they are resident in Spain or even in another countries of Europe or outside of Europe.
And so when we're talking about sort of this time span, 2000 to 2016, why does the compensation opportunity specifically apply to those mortgages? What happened after 2016?
Right. Well, in 2016, due to the Supreme Court ruling, what the banks did quite cleverly, they started changing the mortgages basically. With some clients, they would call the client, they would send them a new agreement and camouflage it, if you like, into better conditions, where they actually removed this clause because in fear of having claims against them. So that's why we won't generally see any mortgage after 2016 with these abusive clauses applied. We can see the mortgage expenses up until 2019, roughly. So if you've got a mortgage after 2016 up until roughly 2019, we can still have a look at your mortgage deed, along with if you have the invoices of the expenses. We can still have a look at that. But basically, that's where they stopped applying because they knew they were going to have a problem, basically.
And so, I mean, with us talking about this today, is that because there's sort of a statute of limitations? Is there sort of a window that's that about when we can make these claims, or is it more open than that?
Well, actually, the nullity action for these abusive clauses and claims against the banks, they don't have a statutory period because they're considered null and void. Now, it is important to note that there is a 5-year window. So if anyone did get in contact with a bank to request an out of court or an extrajudicial claim to try and get their expenses or back, it means that then the time runs from that time. So if they've never made a contact, no problem at all. If they did, then we need to count 5 years from that time. And even if the bank didn't answer their request, it still counts. So even so, though, we do recommend making a claim as soon as possible, because there's always a difference. They will be interpreting it, and the law will be changing gradually. At this point, it's very favourable, so it's definitely better to get started now.
Excellent. Actually, and Mariam, something which we spoke about ahead of the call, just to be able to give clarity to people who are watching now, the process of an application. I think people have Spain potentially has an unfair reputation about bureaucracy and things taking longer than you would necessarily hope with these sorts of things. If someone was to get in touch with you today about making a claim, or to even work out if they were owed compensation, what are the next steps? How long does this all take?
Well, it's actually a fairly quick process. What we start off by doing is an out-of-court claim, which is basically contacting the bank on the client's behalf, and we give them a 30-day deadline to reply. Now, what we're seeing with most banks, not with all banks, but quite a few of them, they're actually they come across and they start offering. They don't always start at the best offer, and we get what we want with a lot of them. In a few cases, we then have to go to court, which then it could take some 8 to 12 months. But most of these claims we see solved in almost a month, which is great news.
That's fantastic. And so actually, one of the things which you mentioned in the introduction was the IRPH. And so could you explain a little bit about exactly what is the IRPH index and how has it led to these overpayments?
So basically, it's a benchmark interest rate that basically all the Spanish banks introduced to our Spanish mortgages. So it was really similar to the Euribor, but the calculation was different. It is true that was more stable, but that made basically all the mortgages expensive because the rate was more difficult to lower down. So that's the reason all the clients that had that rate in their mortgages at the end paid most on interest. So that's the reason, and that basically was the difference between the RRPH to the other interest in the mortgage.
Can I just add there? Sorry, can I just add there? It's quite important. The mortgages that we see that have the IRPH index applied, they're actually where we have normally the biggest claim amount. You can be looking at, especially if it's a mortgage dated back from 2000 or 2005, you could be looking at amounts to be claimed back for 40, over 40,000 euros. We've seen quite high amounts, so it's definitely an interesting subject.
And is that simply because someone will have been overpaying by a more substantial amount, and so they're being owed the compensation for the full amount of overpayment?
That's correct, and they will get the legal interest dating back to the day of signing the mortgage. So the legal interest is quite a large amount as well.
All right, and also I suppose if people have been taking if this was on a mortgage from 2000, 2001, and we're talking 23, 24, 25 years of interest on that compensation as well.
That's right. You're talking about thousands of euros potentially.
Well, and so, I mean, are we able to talk numbers at all in terms of what kind of compensation might be expected based on those claims? But you mentioned there sort of 30, 40,000 euros. And do you know how this is calculated?
So basically here, well, Mariana, if you want, Mariana basically did this kind of calculation, so maybe it's easier to explain everything.
Well, when it comes to floor clause, we can easily calculate because we have a firm judgment, with the same with expenses. It really depends on the year the mortgage was taken out and the amount of the mortgage. Obviously, it's not the same with a 60,000 euro mortgage to a 300,000 euro mortgage. But we see claims anywhere from, it could be from as low as 5,000, which could be only expenses, up until 50,000 euros. So really each individual mortgage needs to be calculated, but we carry out a free of charge viability report, and that's done within a couple of days of receiving a copy of the mortgage deed.
Fantastic. And I suppose actually, like, this sounds like it's quite a widespread issue, like it impacting multiple banks. I mean, are you able to say sort of which of the banks which were most commonly involved in these missold products? Just, I suppose, people who are at home to be able to work out whether they might have been missold.
Yeah, well, basically, CaixaBank was one of them. Santander, which was previously called Popular, the Sabadell. Most of these banks were named differently, and then they've merged, which most of you probably know. Bankia is one of them, and one called UCI, which is part of the Santander group. But I wouldn't really restrict myself to a certain bank. As long as the mortgage was taken out in this time frame, we're happy to have a look at it, free of charge viability report, no problem at all.
That's great. And actually, as you say, some of these banks have renamed, so they've merged. I mean, I imagine some may not be in business anymore. And does that impact the claim at all?
No, not at all, because the absorbing bank would inherit the legal responsibility. So say Banco Popular was taken over by Santander. So if you took out a mortgage with Banco Popular, Santander would have to respond, and obviously the banks are solvent, so we're not having any difficulties there at all.
Fantastic. And so I suppose as well, like in terms of if someone was to be hearing what we're talking about today and they were going to get in touch, you've already mentioned mortgage deeds. What sort of documentation should someone have on hand? What's most useful to you?
Right, well, basically, in principle, what we need is the mortgage deed. Now, it's important to distinguish between the mortgage deed and the title deed, because the client would have two deeds. If they're not sure, then we help out. We have a quick look at it, and we'll be able to tell them. But what we're looking for is the mortgage deed, and then we'll see that the bank has been named in the first couple of pages. They will see the name of the bank as well. With this deed, we can then tell them fairly quickly if a floor clause was added, if they've got the clause where the client had to pay for the expenses, etc. So that's fairly simple. We can also determine the IRPH, although at this stage, the whole Spain is waiting for the final judgment on the IRPH, which means that we need to wait for the exact calculations, but we can still take that on board because we know that it's going to be a very good claim.
And in terms of the language you're looking for, I mean, essentially, are there people who will have been if someone has got a mortgage in that time span, 2000, 2016, what you're talking about doesn't apply to every mortgage, right? And there is a chance that someone would submit and their mortgage doesn't involve one of these clauses. Is it a case of what is it that they need to prove to be able to have a successful claim?
Right. Well, like I said, it's very simple. As long as we can have a look at their mortgage deed, we will be able to tell. Not every single deed, not every single mortgage had an abusive clauses added to them. So we'll be able to tell them if an abusive clause was added and the amount that they may claim. Now, if they don't happen to have the floor clause or IRPH, what we can do is we can make a claim for the expenses, which would be the notary fee I mentioned previously, the land registry, the valuation fee, but we do depend on them being able to provide copies of the invoices, so be the notary invoice, etc. So they can always claim for the expenses, even if we don't have a floor clause claim.
And also, if someone doesn't have a copy of their mortgage deed anymore, is this going to be a problem? Are you able to track down original paperwork, these sorts of things?
It's not a problem. Obviously, it's great if they can provide the deed, but we often see because 15, 20 or more years have passed, sometimes it's difficult to find. And also because you're looking at a document which is in Spanish, it's kind of, we don't all understand the content of it. So first of all, we always try to send examples, what to look for. If they can't find it, then we always recommend to look through old emails to find the name of the solicitor in Spain that would have helped them. Then they can either email the solicitor and ask for a copy, or we can email the solicitor on their behalf with an authorization. So that's a good start. If the solicitor no longer exists or haven't got anything on file, then we can take out something called a notice simpler, which is a simple note, which will say, state basically which notary, where they signed the deed at the time, or their lawyer signed on their behalf. And then the next step would be to contact the notary to try and to get a copy. So there are ways around it.
And not to try and talk you out of work on this at all, but why is it you'd recommend people actually seek out your services for this rather than, I don't know, Control F on their old mortgage deed to see if they can mention a floor clause or things like that?
Well, I think it's well worth it, because we're seeing large amounts of money that can be claimed. It's money that they've overpaid, which are theirs. So it's definitely worthwhile, because a large percentage of these mortgages were missold, and it doesn't require much effort from the customer side. And as we can offer a no-win, no fee, and the viability report is no obligation and free of charge basically, then they've got absolutely nothing to lose. So it's definitely a good opportunity to make a claim. All we need is that tiny effort for the deed, and then we'll do the rest.
That's great. Well, so I mean, like, I just wanted to, before turning to questions from people watching at home, just to sort of summarize and hopefully make sure that I've fully understood. So between 2000 and 2016, many banks in Spain missold mortgages to international and local buyers. People have discovered this was a problem, and the Spanish government has set aside a fund to compensate people who were missold these mortgages. If they were to get in touch with you today, in the coming week, and provide a copy of their mortgage deed, then you'll be able to quickly search through that to see if they are likely to have been missold a mortgage, at which point you're able to then start filing a claim on their behalf, and they'll be able to get you'll be able to tell them how much they may be owed in compensation, but then also actually get that compensation for them. And it's a no-win, no-fee situation as well. So there's no cost to them to get in touch, no cost for them for you to do that search for them, and no cost to them for you to do the calculation to see how much they may be earned in compensation.
That's right.
Perfect. Okay, well, with that in mind, I'm going to turn to a couple of the reader questions. Well, actually, the first question was, I hope answered in that summary, which is saying, will you be able to obtain a copy of my mortgage agreement, which is something which you've already talked to, and do you have an upfront fee, or it's no win, no fee? So just to absolutely clarify, at what point would anyone pay JLCA?
Right. Well, like I said, it's a no-win, no fee. The viability report is completely free of charge, and there's no obligation as well. The only fee we wouldn't cover in this process would be in the event that the client has to sign a power of attorney. If the claim doesn't get solved out of court in those first 30 days and it's got to be taken onto the court, we would need a power of attorney to represent them. Now, the only fee we don't cover is the fee to the notary. That will be paid by the client directly to the notary on the day. We don't make anything on that, and we will help them find a notary, whether they're in Spain or in the UK, wherever they're based. So that would be the only fee that we don't cover. So, and in the event of a non-successful outcome at court, even though we haven't had those yet, we would even cover the expenses, the costs. So no risk at all, really.
And also, this may be difficult to speak to, but in terms of the scale of the problem and like the number of claims which are being made, are we talking thousands, tens of thousands? Like, how common a problem was it when people were getting mortgages in that time span?
Yes, you are talking thousands, millions. And not just amongst foreigners, but among Spaniards as well. It's a very, very big issue.
Okay, so really it is very worth anyone who has taken out a mortgage in that time getting in touch, but checking and getting in touch with the people they know who also bought mortgages at that time, because it is a very widespread problem.
That's right.
Okay. And then, I mean, actually, the questions we're having, I think, have been covered off in the summary and what you've been talking about here, which is talking about that time span. So it is, again, that idea of if you got a mortgage between 2000 and 2016, this is very likely to, there's a chance that this will apply to you, and it's something which you should get in touch. And was it you also said that if they got a mortgage out between 2016 and 2019, it's still worth checking as well, just in case they fall into sort of the last embers of this. Again, I'm pulling words from.
That's right. That would be a matter of the expenses. It'd be a claim for the expenses and legal interest. So it's still worthwhile. We can still have a look at that. We would need the deed, and we would need copies of the expenses, the invoices of the expenses, if they can provide these.
Excellent. And I suppose please do write in your questions if you've got any more to ask. We've got a little bit of time left. But one thing, and just to sort of, I'm afraid this is going to be a bit of a repeat, but if we could ask a bit about the process. So just to clarify, if someone uses the QR code or the email address, which is up on the screen at the moment, what happens next?
Right. So once they contact us, we will then help them. If they're not quite sure what they're looking for, we'll help them with the process of finding the mortgage deed. Give them some tips for the best way of contacting. Like I said, we can contact their Spanish solicitor, and there are different ways around trying to obtain the document. Once we've got the mortgage deed, we will then, in a matter of a few days only, be able to tell them if they have a viable claim. The lawyer will prepare a viability report with the calculation for the amount and the legal interest, and then we prepare a client fee agreement to show very transparent, with a no-win, no fee. Everything's clearly stated. So they would need to sign the client fee agreement and an authorization. Once we've got that, we will then start with an out-of-court claim, which means they don't need to go to notary at that stage. And if we're lucky, we manage to settle this, and we're having payments in a month, 2 months. Now, some banks want to take it a step further, which means that then a claim will need to be filed. The client will then need to sign the power of attorney, but we prepare the draft. We help them find a notary wherever they're based. So it's a simple, nothing to worry about. And once we've got the power of attorney, we then file a claim.
Excellent. And so again, there's one piece of information which you said earlier, which again, so there isn't a statute of limitations on these things. If you, even if this is going back 25 years, as in the year 2000, they can make their claim. There's no sort of limit on that. But you mentioned something about a 5-month window after a certain action. What was?
Right. So basically, there's no statutory period. However, if somebody contacted their bank at some point because they thought they'd heard about the expenses claimed, or they would meet contact saying, I think I've been paying too much, I'd like to claim back the amounts overpaid. The bank, even if they never answered you, if that letter exists, communication or email, that means that there is a 5-year limitation on that. So that would be from that date that they received, even if you never got an answer, because quite often they don't even answer, they ignore any attempt, especially if it's not coming from a lawyer. That means that we would need to calculate those 5 years, but it's very seldom with English non-Spanish, basically, that would have tried this. It's not very common.
And even if they have it or suspect they might have sent an email in the past, it's still worth getting in contact to start chasing that claim just in case.
Absolutely. But it is important that they let us know if they've tried to make contact and they've tried to make a claim. It's important to know.
Excellent. So I think we've not actually had any more questions in. So just as a wrapping up phase, if people do have a question, this is absolutely the time to do it. You've got 2 legal experts on the webinar right now who can answer your question. But if you are thinking about what you do next, as we've covered, use the QR code, use the email address which is on the screen at the moment. Do get in touch to book a one-on-one session, talk through your case. The best thing you can do to prepare for that call will be to get your original mortgage deed. But that's not a reason not to book the call. Book the call, get it in the calendar, get the conversation started. But also, as I hope has come across from what we were saying in the introduction and what we're saying now, is that there's a good chance that you've been impacted by this if you got a mortgage between 2000 and 2016. It's very much worth checking. But also, if you know people who were in a similar situation who bought in that time period, that they may well also be impacted. They may also have a right to a compensation claim. And so do share this webinar, do share the contact addresses which are on the screen, and encourage them to get in touch. This is an opportunity to potentially get thousands of euros in compensation, particularly if it's dating back to the beginning of the scheme, or that if they've had a particularly egregious clause on their contract which needs to be compensated. So what I would say is thank you so much to Marianne and Christina for taking the time to talk this through. It's a complicated situation. It sounds like it's something which is well worth people being in touch. So thank you for explaining it to us today and answering all our questions.
Thank you so much as well for your introduction and for your time.
Yeah, thank you for the time.
No worries at all. If this has been a helpful webinar, please do leave a review for us on Trustpilot. It's an extremely helpful way for us to know if we're doing a good job, but also it helps other people see us and learn about the services that we offer. Also, we would really recommend registering for the Overseas Virtual Property Show, which is going to be taking place in October. This is a single day event, but we bring together hundreds of other property viewers. We bring together agents, lawyers, solicitors, so everyone that you would need in the property buying process. And it's a great opportunity to sort of learn everything you need to know about buying a home overseas. But as the last final sign off would be a case of, if you bought a home in Spain between 2000 and 2016, use those details on the screen at the moment, book that call and find out whether it's something which you're able to claim compensation for. Thank you very much for taking the time to tune in and ask your questions, and hopefully catch you on the next webinar. Thank you all again.
Thank you.
Bye.
Bye.
Thank you.